Thanks everybody very much for coming and staying for the last presentation. I know there's a great temptation to leave. I'd like to say I spoke very briefly to the tax group earlier. I'd just like to say how thrilled I am as managing partner of Thompson Dorfman Sweatman to be here with the Roy Johnston firm. The partners, associates and staff of the Roy Johnston firm have made us so welcome in the discussions that ensued about a year ago, I guess, that ultimately led to the merger of the two firms. And we've had people coming and going and being involved in various events in Brandon over the course of the last few months. This is our biggest endeavor to date, and I'm just absolutely delighted at the number of people that are here and how welcome you make all of us feel. So thank you very, very much. When the regulators come calling is something that I have to be a little bit aware of on a personal level, and I'll touch upon that a bit later, but law firms have to be concerned in particular when either prosecutors, criminal prosecutors, or tax prosecutors come walking through the door and say, you act for this bad person, that person, the other bad person, and we think that you've got all sorts of information in your files about that person that would be really useful to us, and we have a warrant to take all of your files away and study them to see if we can prosecute that person. So that's the when regulators come calling concern for lawyers, and I'll tell you how we would respond to that. We're living in a world, where am I now? I have to figure out how to use this. I am not, as Mark will attest, I am not a technical person, as Kevin will attest. We'll see what happens here. This just might blow up. No, it didn't blow up. I'm not going to just read these out to you. We're distributing, are we, Mark, this to everybody? Good. On your memory stick, which I don't actually know how to use. But for those of you who do, apparently these are on your memory stick. I'm not going to just read them. I might highlight some of them, and I made some of my own notes. So the bottom part of that says this presentation will address regulatory compliance generally and the systems, policies, and people you need to have in place to prepare for a regulator's visit. This material was actually prepared by my partner Vivian Rackless. Vivian has been a partner of ours for very many years, with the exception of about a 5 or 6 year hiatus. She does litigation and labor and employment work with a special emphasis on health law. And her hiatus was to become in-house counsel at the Winnipeg Regional Health Authority, where she developed a very significant body of knowledge about health law and regulators and the Winnipeg Regional Health Authority and the health authorities generally. So she prepared this material. I take no credit for it. But it seems to all of us, I'm sure, that politicians' promises to the contrary, we're all living in an increasingly regulated world. Almost every industry has some level of regulation or not, or more, greater or lesser regulation. Some of them seem to be regulated pretty much to death. Most of the time, the regulatory activity is pretty benign. So you know when to expect the inspectors there. If you have a plant, they're in your plant on a regular basis. If you're working in the food industry, they're taking copies of reports that you've been making in order to do quality control checks and matters of that nature. And they're kind of a ever-present, you're paying them indirectly, and they're affecting your work on a day-to-day basis, but it's really not particularly threatening. And usually it's a fairly cooperative relationship. So if the inspector does detect something that's amiss with respect to the particular operation that's being inspected, they'll come to you on a fairly low-key basis and say, you know, Jack, this is not quite what it should be. What can we do in order to put it in good order? I need you to attend to this, and I'll be back in 2 weeks and check it out, and if you've got it fixed, it'll be fine, and if not, we're going to have to get more concerned. So they're there, they're benign, they're very much in the interest of the national policy in terms of making sure that the citizenry is protected while living in this country. But occasionally, you might notice an attitudinal change in your inspector. So for the 5th time in a row, the inspector has come back, and that which bothered him for each of the last 4 times is still bothering him. And he comes up and he says, you know, Judy, I've mentioned to you this 4 or 5 times. It's still not fixed. I'm getting very, very concerned about this, and we need to do something, and we need to do it now. When you see that attitudinal change, you should have all sorts of spidey senses going off, because the whole relationship can now change from a fairly benign relationship with an inspector who's just really making sure that you're in line with the regulatory authorities to somebody who's turning cop on you. And you need to be very concerned about that person when that person becomes cop. Sometimes it's even worse. You end up with, and this actually most frequently happens after some sort of an incident. So an incident happens, someone is hurt, food goes out that has to be recalled, some significant thing that everybody recognizes as bad has happened, and you have the regulators descending upon you en masse. They're no longer there in their capacity as benign inspectors. They're now cops, and they're there with a view to prosecuting you and with a view to fining, in most cases, the company, in some cases fining individuals that were responsible for the activity. In certain cases there is the specter of potential more serious consequences, jail consequences, etc. Not often, even if it's in the legislation, not often pursued except in the most heinous of cases. But it's something that when you notice this attitudinal change, or if you have them coming through the door as a result of an event, you need to be very, very careful about where do you go from there. One of the number one features that you need to do if you're in a regulated industry, and most people probably have this in place already, but it's very, very important that you have a select few, could be as few as 1, could be you, but a select few people in your organization who are really familiar with the regulatory environment. They need to understand the regulations under which you're living. They need to understand the reason behind the regulations. They need to have a working relationship with inspectors if inspectors are present in your facility on a regular basis. They need to understand the potentially penal sanctions that can follow from not being in compliance with regulations. And they need to understand what to do if they notice this attitudinal difference. So it's important to have your own internal policies in place, so that you need to understand what the regulations are and then model your own internal policies to comply with the regulations, because ultimately it's going to cause you misery. And in some cases you get, particularly, we all know about food recalls, XL and food recalls in the food industry, what it did to, what do they call, McCain's, close, but you're right and I'm wrong. What happened to McCain's, which turned into the probably most brilliant example of crisis management ever seen in the country, but could have put the company completely out of business. And so you really do need someone who understands the regulatory environment and the regulators and what to do if there's a problem. This is neat. There's a distinction, again, coming back to, and what we're going to talk about a fair bit, is the distinction between inspections and investigations. So the whole idea of the inspection environment is to monitor compliance. So that's why the inspectors are there. They come and go on a regular basis. They've got a set of regulations. You've got a set of procedures. They're monitoring compliance to make sure that your organization is in compliance and to help you get into compliance if you're not. Investigations are to prosecute for non-compliance. And there's a big, big difference. Inspections are to promote compliance. Investigations are to prosecute for non-compliance. You don't want to get yourself into the investigation mode. In all, virtually all, probably all, regulatory schemes, there is a duty to cooperate. So there's a duty to cooperate with the inspectors. And in fact, if it turns into an investigation, there is a duty to cooperate with the investigators, who may or may not be the same people. Mostly what the duty to cooperate means is you let them do their jobs. So they have a right to be in your facility. They have a right to examine records. They have a right to take samples. They have a right to prepare reports. They can take pictures. They can do a whole series of things of where they're going about doing their job, gathering information in order to ensure compliance if it's just an inspection role, or to further a prosecution if it's an investigative role. That being said, so your people, in particular, again, these key people in your organization who understand the regulatory scheme, so they need to cooperate and they need to allow the inspector/investigator to do his or her job. One of the things you absolutely don't want to have happen in those circumstances is that person is accused of being obstructive. That can result in charges against both the organization and the individual if they're obstructive. And what it does is it just, from the point of view of the regulator, it just makes the whole environment poisoned. All of a sudden, instead of working with somebody that you might have known for 15 years who's trying to help you maybe a little bit through the edge of this and maybe trying to keep it as small scale as they can, all of a sudden you've got someone who now you're threatening their job. They've got a job to do and you're getting in the way, or your person is getting in the way of their ability to do their job, which is a threat to them. So they react poorly to that. So you need to try to maintain the cooperative approach to dealing with the inspector/investigator throughout the entire process. That's different though, very different though, than a duty to self-incriminate. You don't have to fall on your sword. One of the great challenges that we Canadians face is being too nice. So somebody comes in and they're doing an inspection/investigation. It's on the edge of the investigation, and they say, you know, Bill, that's a really sloppy procedure, don't you think? We don't want Bill saying, oh yeah, that is a really sloppy procedure. I'm sorry. I guess it did lead to that man getting his hand chopped off. That's self-incrimination. You don't need to do that. That's more than cooperation. That's going way beyond what they have a right to inspect you to do. If you're put what are called leading questions, lawyers love leading questions. If you're being asked for information, you have to give facts. Did his hand get caught in the machine? Yes. Did his hand get chopped off? Yes. Those are facts. It happened. We don't want you giving opinions. Why? The guy over there was sloppy. They didn't put a cover on it. We screwed up again. You don't want any of that. So you need to caution your people that if they're being asked questions that are purely factual in nature, then under the duty to cooperate, you provide the information. But you don't speculate about anything. All you're doing is you're answering questions, and there's nothing wrong with, I don't know. What happened? I don't know. I wasn't in the room. I didn't see what happened. I don't know. Well, what do you think happened? Sorry, I don't know what happened, and I'm not going to speculate on what might have happened. That's beyond my duty to cooperate. And so you need to bear in mind it's a fine line, but a very important line. Okay, this is just an example. This is an extract from the Workplace Safety and Health Act, and it says every person who, and if you see the C down there, knowingly obstructs or makes a false statement to a safety and health officer engaged in the exercise or performance of his or her powers or duties commits an offense. So this just comes back, this shows you that it's just an example, that there could be tens of others from different pieces of legislation, but it just goes to show that if you as an individual on the floor are accused of obstructing an investigation, you could be charged. It's not your employer that's going to be charged. You're going to be charged with obstructing. And so it's in the legislation, don't obstruct. Okay, the powers of the regulator, and again, this comes back to something that I alluded to earlier, is that the powers of the regulator which are outlined there, are essentially that I can come into your facility and do what I need to do in order to do my job. I have the power to do that. I have the power to inspect. I have the power to take samples. I have the power, et cetera, et cetera. So in order to do my job, I have these powers, and you cannot obstruct me in the exercise of my powers. But that doesn't mean, and coming back to the theme that I've been harping on a bit, that doesn't mean you have to do their job for them. So you should always have someone, if there's an inspector, and this is not the routine day-to-day inspection that goes on for years in a row, but if your senses are, if the people that are dealing with them is that this is on the edge of or has already turned into an investigation, you need to have that knowledgeable person with the inspector all of the time. That person needs to make it his or her own record of what the inspector did. If the inspector's taken pictures, the person should be taking pictures. If the inspector's taking samples, the person should be taking samples, so that at the end of the inspection, when the inspector is finally done, the person who's accompanied that person, A, knows that there's nothing the inspector did or saw during the course of the inspection that the person did not see. So there's no surprises. When you get to a hearing, you don't find that this person picked up some log and walked away with the log, which contains incriminating information, and your people don't even know about it. So you need someone with them all of the time, making a record of what's happening, cooperating with them, allowing them to do their job, but you want to know as much about what they've done as they do. So here we've got the slide, regulatory compliance, legal framework, inspections versus investigations. Again, this is really just repetitive of what I've already said, that the inspections are essentially benign and intended to ensure compliance, and investigations are not benign, they're prosecutorial, and they're intended to ensure convictions. It took me a while to figure out what Vivian was saying. Oops, next slide. Regulatory compliance, legal framework, inspections versus investigations. And again, this is mostly similar to what I've done. This slide talks about the essence of inspections. We've touched on that. The thing that caused me some pause, you note the third bullet, broad powers to conduct inspections, and I didn't know what that thing was. Ultimately concluded it does not equal. So you had equal with a stroke through, I didn't have any idea what it was. Broad powers to conduct inspections does not equal collecting evidence to support a prosecution. So there's limits on what their authority is. If they're, and we're getting to it now in this favorite, this is Vivian's own personal favorite case, R versus Jarvis, a 2002 Supreme Court of Canada decision when they were talking about the distinction between inspections and investigations and what happens when you cross the line. And they talk about crossing the Rubicon. And this is from the point of view of the inspector crossing the Rubicon, and all of a sudden it's going from the benign day-to-day routine inspection activity to prosecutorial activity. This person has detected what he or she believes to be an offense that is worthy of prosecution and is now turned into Sherlock Holmes, gathering evidence with a view to putting you in jail. It's kind of the way you need to think about it. And so what they're talking about doing, for so long as the predominant purpose is monitoring compliance and it's an inspection, then that is an inspection. If it's for prosecution, then that's an investigation. And the reason that it can be important is that once you slip over into the prosecution side, you get into a whole field of which I know very little, which is essentially the principles of criminal law. And the main principle of criminal law that applies, and these come from the Charter of Rights and Freedoms, is that you're not obligated to give evidence against yourself. You have the right to remain silent. And so once it slips over, your rights in terms of their rights start to become more limited, your rights start to become greater in terms of a declining degree of need to cooperate once it clearly becomes an investigation. And as I said earlier, it's up to them to prove their case. You don't have to prove it for them. And so if you get into those circumstances and the questions are continuing, and believe me, for any of you who have ever had to deal with the police, because they're getting close to the edge of a charge of some kind, doesn't mean they stop asking questions. And they're just going to keep asking questions for as long as you keep answering questions, and they'll give you leading, wasn't that a terrible mess? Yes, it was a terrible mess. Leading questions. But if your person who's dealing with them finally gets to the position that all of a sudden the light goes on and that person says, like, this is an investigation. These guys are going somewhere. There's going to be charges come out of this. Then I think what you should do is say, sorry, I need a lawyer. I'm not here to incriminate myself. I'm not here to incriminate my employer. I'd like statements from here on in to be with the benefit of counsel. And then at that point in time, get a lawyer involved who's knowledgeable about these issues and respond to it from there and on that basis. The next slide. Whoops. There we go. So these are the factors that the Supreme Court talked about, is to try to figure out whether it's an investigation or an inspection. And when they say that the factors have crystallized and it's now an investigation and a whole new set of duties arise, and they look at the existence of sufficient grounds, et cetera, all of these sorts of things, that's what they look at. It's interesting, though, like this Supreme Court of Canada case probably took place 6 or 7 years after the events in question. If it moved along with scintillating speed, it could have been 8 or 9 years or 10 years if it moved along at slow pace. The decisions that your people on the ground have to make are right now. It's nice in the cold light of day, 2 months, 3 months, 5 months, 8 months later, was this an inspection or an investigation, and what were they doing? So what you need to do is, sooner rather than later, suspect that it's an inspection or an investigation, and react then on the basis that I think I'm under investigation here. I need to be more careful rather than less. Your slide and mine are the same. There's nothing wrong if you're dealing with an inspector and during the course of the work that the inspector is doing to just simply say, like, are you going to charge us with something? And just see what kind of a response you get. If they say yes, then there's really no issue about what's afoot. If they say no, they might have put themselves into a corner that they might subsequently regret having done. But it's a good question to ask and see what the response is. Sorry, can't tell you. That tells you they are thinking about it, pressing a charge. And then if they want to start taking stuff away, if you get it to a point where you really are pretty certain that this is an investigation, you're really pretty certain the charges are going to lay, and they say, I'd like to take away that log with me, it's also legitimate, and as I say, you should have your lawyer motoring his way over to your place of business by this time. But it's also legitimate to say, do you have a search warrant? On what basis? I think I'm being investigated. I think we're likely going to be charged. Do you have a search warrant? What is the basis for taking away that log? Why are you authorized to do that? And again, they'll if I had to have a search warrant, then they'll show you the search warrant. You can look at it yourself. Make sure that it says what it's, I mean, it should say a certain date, time, place for a certain purpose. Look at the search warrant, make sure that they're doing what it tells them to do or gives them authority to do. Again, get it into the hands of your lawyer, and she'll tell you whether or not it's a proper warrant and whether or not you need to respond. This is where I was going to refer when the regulator arrives. So this is stuff you can look at and think about at your leisure. These are just good points. They're more or less of what a summary of what I've just been saying. But let me, for a second, if I can find it. This is a little thing that the Law Society of Upper Canada, Ontario likes to call itself Upper Canada. The Law Society of Upper Canada issued a book, 14 pages of small type, what a lawyer is supposed to do if Canada Revenue or Prosecution's Department arrives in the office and says, I want to take this, that, or the other thing. 1, ensure that the law office is identified as the place to be searched. 2, ensure that the date the police have attended at the law office is the date authorized. 3, ensure that the documents sought are identified. 4, ensure that the offense under investigation is identified. Ensure that the requisite judicial officer has signed and dated it. If there are deficiencies on the face of the warrant, point them out to the police and assert that the police should obtain a proper warrant. But do not obstruct the police. And assert privilege over all documents. And privilege is an important concept. By and large, privilege attaches to communications between lawyers and clients. And there are some features to that given for a certain purpose, et cetera. But from your point of view, you should assume that during the course of one of these investigations, that privilege attaches to every single communication between you and your lawyers. So if this has been something that's been a problem in the past, so there's been 3 or 4 of these instances, and finally they're getting to the stage of where they're maybe going to press charges, and you got a file. And in your file, you've got letters back and forth to your lawyer, you've got emails to and from the lawyer, you might have transcribed voice messages, you might have transcribed texts. You should be taking the position with the inspectors, that's all privileged. You're not allowed to see any of it. What we're going to do, and again, and it's interesting, this dichotomy between having to cooperate but being able to protect your own rights. So you assert privilege. You're not allowed to see that, not any of it. What we're going to do is we're going to get a big envelope, and we're going to put all that stuff in the big envelope, and we're going to seal it. And we're both going to sign across the seal, very dramatic, so that you've got the cop's signature and your signature across the seal. And then you say, okay, what we're going to do is we're going to give this to your lawyer, inspector guy, if your lawyer wants to take it, or my lawyer wants to take it, somebody wants to take it, somebody who's independent of the parties. And then what can happen is ultimately that envelope would go before a judge. And the judge would then look at each and every document and hear arguments from lawyers for the parties as to whether or not they're properly privileged. Because if they're privileged, they cannot be used against you. So you might have a letter from your lawyer saying, I warned you about this, I warned you about this, I warned you about this. You know what, that read out in court when the case comes along. And so that would be a privileged document, and as long as nobody waived the privilege, and so you would waive the privilege when the inspector comes into your office and says, what's that? Well, that's the file that I keep for correspondence with my lawyer. Well, can I look at that? Sure, no problem. Here it is. You can look through this because my lawyer tells us that we're A-OK and we're not going to get convicted of anything. And you can take it away. You can make a copy of it. You know, every single scrap that's in that file, you've now waived the privilege that you otherwise would have had without your lawyer having had an opportunity to think whether that's a good idea or not. Because sometimes the lawyer will look at it and say, it is a good idea. You know, we did tell you. Here's what we told you to do. Here's what you've been doing. It's a good idea to waive the privilege because it shows that you've been trying to comply. But you don't want to make that decision by yourself in the office with the inspector standing in the door. So that's an important thing about privilege. And I think finally, and you've been very patient, yeah, this is all the stuff that I've told you already. Follow it. That's all I'm going to say about that. These are good rules. Follow it. Solicitor-client privilege, we just talked about this. Conflict of interest is the final point that we'll touch on. You can get into a conflict of interest in the regulatory sphere between an employee and his or her employer. So employers, if they're corporations, they're not warm and fuzzy, they're not living, they're incarnate entities that have all of the characteristics of a living person as far as the law is concerned. The way they act is through their employees. So corporations come to life through their employees. But the corporation might well take the position of, well, we didn't intend to break the law. Look, let's go to the board of directors minutes and the policies and procedures and manuals and guidelines and everything else that we've laid out, and we've held courses and we've told these people they're supposed to do this, that, or the other. It's not our fault. That guy over there, he never was a listener. And we think it's his fault. We think that he dumped the ladle of hot steel on the employee that he didn't like because he lost at cards the night before. Now you got a conflict of interest. You got the interests of the employer and the interests of the employee, and they're not the same. They're in conflict. So they can't have the same lawyer, because the lawyer is bound and determined to represent the interests of his client or her client, and so they need separate lawyers. And so you just need to be alert to the fact that you've got different personalities at play. You might have your corporate facade at play and your individual facade at play, and that those might not necessarily line up, and you need to be careful about that issue, and you need to talk to lawyers about it and get it straightened out so that people don't inadvertently cause themselves misery. We talked about privilege. We talked about privileged documents, practical advice, etc. Don't have many of them. Keep them safe. You can look at all of this stuff. Conflict of interest, we just talked about it. You can look at that stuff too. Summary. Proactive steps in place before the regulator arrives. Make sure that you got a person who really understands the regulatory scheme, the purposes behind it, and how to deal with it in shop. Legal duty to cooperate, we've talked about that ad nauseum. Inspections versus investigations, similar. Legal privilege and conflict of interest. So that's kind of what I have to say. But I'd be delighted if anybody has questions. To the extent of my ability, I'd be pleased to respond to them. The perfect presentation. It answered all of the questions. Thank you very, very much.